Freshman year, my freshman year.
All right, you can be seated.
I'll introduce your presiding judge. This is Kunde, head of the United States Attorney's Office, a two-time All-American in college, trial lawyer here in Los Angeles. Judge, the court is yours.
All right, let me just pull up my ballot. Where is it again? That's a joke. All right, are both parties present and ready to proceed?
Defense is ready to go.
As is the state, Your Honor.
All right, pretrial matters from the state?
Your Honor, before we proceed with pretrial matters, permission to make appearances before the court.
Sure.
Good afternoon, Your Honor. My name is Audrey Vanderslice, and I, along with my co-counsel, Ms. Jessica Alexander, we represent the plaintiff, Mr. Jones' estate, the decedent in today's case.
Okay. Defense?
Yes, Your Honor. Good afternoon. My name is Jackson Kunde. Joining me at counsel table today is Ms. Lauren Stoneman.
Good afternoon, Your Honor.
Good afternoon.
Together, we represent the defense, Dragon Studios. Seated at counsel table with us is their founder, Ms. Kunde.
Good afternoon.
Good afternoon.
We're going to proceed with pretrial matters?
Yes.
Mr. Presiding Judge, time out.
Yes. All right, and let me just go to our scores real quick. Any conflicts from anybody? Okay. Okay.
No, this.
I'm sorry?
Yeah, not a conflict procedure as this one.
Perfect. All right, pretrial matters?
Yes, Your Honor. At this time, we'd like to invoke Rules 603 and 615, the constructive swearing in and sequestration of all witnesses barring party representatives. Today, the plaintiff has no representatives in trial.
Okay.
Yes, Your Honor. We'd agree with that. Ms. Doig is a party representative, going to be seated here throughout this trial.
Okay.
Your Honor, I'd also like to draw the court's attention to a pretrial order. Under pretrial order 9, any witness who isn't testifying at trial is stipulated as unavailable within the meaning of Federal Rule of Evidence 804A.
Say that again.
Yes,
Who's not available?
Any witness who isn't testifying in today's trial but has been deposed, they're stipulated as unavailable
I see.
within the meaning of 804A.
And is that true?
Yes, Your Honor. No objections.
Okay.
With that, Your Honor, the plaintiff is ready for
All right.
statements.
Yes, Your Honor. Just a few matters. First, we'd like to address your permissions for moving about the courtroom, the while approaching the members of the jury and the witnesses.
You have free permission, just ask for permission to approach the witness.
Great, Your Honor. Then we'd like to point you to a few exhibits, 1 through 25. Those have all been pre-admitted. We want to use a few of those in opening statements. Exhibits 20, 21, and 22. Is that all right with Your Honor?
You said they were been pre-admitted?
Yes, Your Honor.
Is that true?
Yes, Your Honor, that's understanding.
Okay. And do you have any other objection?
No objection to that, Your Honor.
Okay.
And last, Your Honor, we'd like to point you to the verdict form we're going to be using in today's case. It's verdict form B. It states that we're denying the plaintiff's claim of negligence, and we are raising our own affirmative defense to show that Mr. Jones, the victim in today's case, assumed the risk of his stunts.
And so are you doing one or the other, or are you doing both?
We are both denying their claim, so we're going to refute that claim and raise our own burden. Your Honor.
Okay. Sounds good.
And with that, we're ready to go to opening statements.
Ready to proceed?
Yes, Your Honor.
Let's hear it.
May it please the court, Mr. Kunde. Members of the jury. 5 seconds was worth more than a life. It's June 20th of 2023. And Dragon Studios, the defendant company, they're getting ready to wrap up their 7th movie, starring world-famous actor Peter Jones. The crew is breaking down the set. The stunt director is headed home. But the executive producer, Miss Kunde, she's not breaking down the set. She's not on her flight back to Hollywood. No, she is sitting alone in her office. And she is watching the footage over and over again. She's watching her lead actor get on a motorcycle and ride off the side of a mountain and go into free fall until he parachutes to the ground. Now, today you're going to learn that they ran that stunt 6 times. And 6 times they listened to their stunt director's words. They listened to her say that Peter Jones has 4 seconds. 4 seconds to open his parachute or he will plummet to his death. But today you're going to learn that to this defendant's producer, 4 seconds just wasn't good enough. Because while she is watching that footage, she is crunching the numbers. And she has got a record to break, members of the jury. Her last movie raked in $1 billion. She's got to figure out how to bring her audience to the edge of their seat for the 7th time in a row. She needs bigger. She needs better. So what does she do? Even though the crew is packing up, even though the stunt director's gone home, no. She is making a call. Listen, Peter. Today's footage, it is just not good enough. I'm going to need you to hang on for longer. I'm going to need you to hold on for just 5 more seconds. Then you're going to learn. In those 5 seconds, in that 7th time shooting that stunt, she watched as Mr. Jones plummeted thousands of feet in the air, watched as Mr. Jones waited for a signal that never came, watched as Mr. Jones hit the ground 120 miles an hour, all because those 5 seconds, those 5 seconds were worth more than Mr. Jones's life. That's why we're here representing Mr. Jones's estate, Mr. Jones's family, who is suing the defendant company for negligence. Now, in today's trial, the judge is going to explain to you exactly what that means. All that really means is we've really taken on a burden today. A burden to prove 3 things to you by a preponderance of the evidence. That 3 things are more likely than they are not. The first is that company, they didn't exercise the ordinary care that a company should. 2, that Mr. Jones was harmed. And 3, that lack of care actually caused harm. So I want to walk through exactly how we're going to meet that burden. And we're going to do it by showing you 2 things. It was their plan. And they were told not to do it. So let's start with the first one. It was their plan. Well, today you're going to meet Mr. Jones's agent. Let's go here. And she's going to tell you that even though Mr. Jones would come up with the ideas for his stunts, it was the defendant company's job to actually make the plan for those stunts, to actually keep Mr. Jones safe. Which brings us to our second. We're going to find out today that they actually changed that plan. The 7th time the director decided it wasn't good enough, but before they changed that plan, they were told not to do it. You see, every witness that's going to take that stand is going to have to admit that plan they ran on the day that Mr. Jones died, it wasn't the plan they agreed to. It wasn't what the stunt director recommended. What's more, members of the jury, is that we expect opposing counsel is going to come up here in a minute and tell you that Mr. Jones knew better. That Mr. Jones actually assumed the risk, but the problem, members of the jury, part of the burden they're now taking on today is they have to prove that Mr. Jones actually understood the magnitude of the risks he was taking on, and there's going to be a problem with that. Because what they're not going to be able to show you today is that he knew. Because what you'll learn is that their own client never told Mr. Jones, in fact, kept it from Mr. Jones that the stunt director never agreed to this plan. Mr. Jones is a celebrity. He probably made more money in a year than all of us combined, but at the end of the day, he was just a person like you or me. And he was a person that this defendant company was supposed to keep safe. And that's why. That's why at the end of this trial, I'm going to come before you again. And I'm going to ask that you find this company lied. Because they decided that those 5 seconds were worth more than a life. Thank you.
Defense, right?
Yes.
Members of the jury, Ms. Vanderslice is right. This plan wasn't safe. He still said yes. There's a reality we have to face when we talk about this case. Mr. Jones agreed to drive a motorcycle off of a cliff. He agreed to do this, to do this, and to do that. So when the plaintiff comes before you and they explain how unsafe this plan was, those aren't just Ms. Vanderslice's words, they are facts. They are facts that Mr. Jones knew far better than any of us in this room. They are facts that Mr. Jones staked his career on. No stunt doubles, no CGI, no backup plans. This plan wasn't safe. Still said yes. So on June 20th, when Ms. Doig goes to Mr. Jones and proposes a new plan to wait until the very last second before pulling his parachute, where even a second delay in radio could mean death. He says yes. And so now today, the plaintiff is suing that studio, Dragon Studios, for negligence. And members of the jury, I want to take a moment to make sure you know what that means. That means today they've taken on a burden to prove their case is more likely than not that what happened with those stunts was negligence. But in today's case, they're not the only one with the burden. What that means is even if Ms. Vanderslice shows you today that it was Ms. Doig's plan, that they were told not to do it, if we can show you that Mr. Jones still said yes, that you can't find Dragon Studios live. And so today we're going to show you that Mr. Jones knew the risks, understood their magnitude, and chose to do it anyway. And we're going to prove that to you today by showing you 3 simple facts. That plan had no room for error, that Mr. Jones agreed to it, and that's why he died. So let's start with that first piece. That plan had no room for error, because you're going to hear today how the two of them came up with a plan to wait until that last second, the last second it was safe to pull that parachute. You're going to hear it as Mr. Jones was plummeting to the ground. The one thing to keep him safe is this. I'll step a little closer, members of the jury. It's a little hard to see. An earpiece. Miss Doig, who is supposed to be in his ear, telling him exactly when to pull that parachute. If this piece of plastic doesn't work, or cuts out for a second, that's it. You're going to hear that he knew those risks, that he signed a contract saying he understood he could die. You'll hear a witness on that stand tell you his words. He understood that this stunt could be the death of him. You'll hear how he adopted a motto, don't be cautious. And you'll hear what happened after. How Mr. Jones jumped off that cliff. And how he never pulled his parachute. That it wasn't until it was too late. And members of the jury, Ms. Vanderslice is going to say to you a lot that 5 seconds are worth more than a life, but what you're going to hear today is that 5 seconds for something Mr. Jones was willing to risk. That's why at the end of today's trial, I'll come before you again. I'll ask you if they met their burden. And I'll ask you if this plan was safe. And if he said yes anyway. Thank you very much for your time. I'm going to approach George. Can we just push these to members?
Sure, these are in evidence.
These are the previous.
Oh, that's right.
cases,
Yeah, yeah. All right, state. You have a witness?
Yes, Your Honor. At this time, we call Ms. Eli Goan.
Okay.
May I proceed, Your Honor? Good afternoon. Can you please introduce yourself to the members of the jury?
Good afternoon. My name is Eli Goan.
What do you do for a living, Ms. Goan?
I am a talent agent. I work with Hollywood stars. I represent them, help them get gigs.
Now, I want to talk about why you're here today. Do you know somebody named Peter Jones?
Yes, ma'am. Peter was my client. A big action movie star. Peter died last year after filming a movie.
And for those of us who aren't as familiar with Mr. Jones's work, could you tell us a little bit about what he did?
Sure. Peter was involved in a big action movie franchise. There were 6 movies and we were about to film the 7th. It's the All Lost series. Think American James Bond. Lots of big stunts, action sequences. He was the hero.
Now, was there a production company who helped create those movies?
Yes, ma'am. That was Dragon Studios.
Well, I want to talk about what kinds of stunts Mr. Jones was performing on set. Was that the first time that he was performing those stunts?
No, not exactly. Peter performed lots of stunts for all of his movies, but for each movie he liked to perform a new one.
Now, what was the stunt that Mr. Jones was going to perform for this movie?
The stunt was that Peter was going to ride a motorcycle down a mountain and launch off. He was supposed to pull his parachute after 4 seconds and land on the ground.
How did you agree what that stunt was going to look like?
Well, Peter came up with the idea, but then we had to pitch it to the stunt coordinator to make it safe. And then through the production company, we also designed the rest of it to make sure that Peter would be able to actually do it.
Did you all ever officially agree?
Yes, we did. We signed a contract and also had a stunt plan.
Now, would you recognize a copy of that stunt plan if I showed it to you in court today?
Yes, I would.
Your Honor, permission to approach the witness and opposing counsel with what has been pre-marked as Exhibit 34, that stunt plan.
Yes.
Thank you.
Courtesy copy for the bench, Your Honor.
Yes, please.
Permission to approach.
Yes. Thank you.
Ms. Goan, what did I just hand you?
This is the stunt plan that the production company set up. It outlined exactly what Peter was supposed to be doing for that stunt.
Is it a fair and accurate copy?
It looks to be so, yes.
Has it been changed or altered in any way?
No, ma'am.
Your Honor, at this time we move to enter what has been pre-marked as Exhibit 34 into evidence.
Objections?
No.
It's admitted.
Ma'am, what did this plan?
Oh, I'm sorry. So it says Exhibit 34 and 35?
Your Honor, we believe that's a typo,
I see.
actually.
Okay.
Yes,
Fair
sir.
enough.
Mr. Goan, what does that plan say was going to happen during that stunt?
So Peter was supposed to start off on a mountain 2,000 feet into the air, ride down a ramp on a motorcycle, jump off, and then after 4 seconds deploy his parachute, and then land on the ground.
And how was Mr. Jones supposed to know when to pull that parachute?
So the producer, Kunde, had an earpiece for Peter to wear. She was supposed to radio walkie-talkie to him exactly when to deploy the parachute.
Well, I want to talk about what actually ended up happening. When was the stunt supposed to be performed for the first time?
We performed the stunt for the first time on June 20th, 2023.
And how many times did Mr. Jones perform that stunt?
6 times.
And how did those 6 times go?
Every single time Peter went off that ramp, he pulled that parachute, he landed on the ground.
Ma'am, I want to talk about what might have changed between the 6th time and the next. Did you ever perform that stunt again?
Yes. Koldoy, the producer, approached Peter and asked him to do the shot again the next day on the 21st. But she wanted to make some changes to how he was going to do it.
What changes did she plan on making?
She said that she wanted a longer shot, that the original shot after 4 seconds wasn't long enough, so she wanted Peter to deploy the parachute after 9 seconds instead.
I want to talk about how that 7th attempt went. Ma'am, who was in the control room when that happened?
It was me in Miss Doig.
How did the stunt begin?
It began as normal. Peter started off at the top of the mountain on the motorcycle. He rode down. He flew off the edge.
Objection, Your Honor, as to a lack of foundation maybe here.
Yeah.
Specifically, just this witness testifying to things were normal. She can testify to what she saw, that she saw him going down that cliff. But to testify to anything else being normal, for example, that earpiece being normal, that's not within her personal knowledge, which she could observe from that control room.
Response on those grounds, Your Honor?
Sure.
Opposing counsel's objection goes to weight and not admissibility. At this point, the foundation on the record is that this agent was part of creating that stunt plan and was there in the control room, had seen the other 6 times. Opposing counsel is welcome to cross on it, but the foundation's been laid.
I take your point, but I think she's right. It goes to weight, not
Yes, Your
admissibility.
Honor.
And you were telling us about how the stunt began. Were you finished with your answer?
No, so he went down the mountain, just like the other 6 times. He went off the ramp, went into a free fall, and he kept falling.
I want to talk about what this defendant's producer did when he went into free fall. Did he signal at 9 seconds?
No, she didn't.
Did she signal at 10 seconds?
No,
Did she signal at 11 seconds?
No, she didn't.
Ma'am, did she ever signal at all?
No. I was yelling at her in the control room to tell him to pull the parachute. She said nothing.
Thank you for your time, Ms. Veglahn. No further questions at this time, Your Honor.
Cross-examination.
Yes.
Your Honor, permission to publish Exhibit 34 to the members of the jury?
Yes.
Good afternoon.
Good afternoon.
I want to start by talking about Mr. Jones. Is that okay with you?
Of course.
Mr. Jones, he was a pretty successful guy, right?
He was great at all the stunts in the movies that he did.
Right. He built his career off these really unbelievable stunts, right?
Well, those were the big action shots of all the movies, but the movies themselves were
Objection,
great.
Your Honor, at this time to character evidence under 404, may I be heard?
Yes. Remind me of the question again.
He built his career off unbelievable stunts.
Okay.
Yes, Your Honor, opposing counsel at this time is using previous instances where Mr. Jones exhibited risk-taking behavior to prove that he would have done the same thing at a later time in this case and acted in conformity with that character trait.
Yes, Your Honor. We're offering this under 404B2 to show Mr. Jones's motive, if I may be heard on those. we're specifically showing the reason why he would take a risk like that. That he'd staked his career on these type of actions, and that's why he would take such a risky action. We're not using this for any sort of action in conformity therewith.
Last word, why doesn't it go to motive?
Yes, Your Honor, we still believe that they're using this to prove a character trait, that it was because he'd done this in previous instances that at this time he was willing to be so risky that he was able to agree to particularly dangerous circumstances in the case we're talking about today. If they wanted to elicit the fact that he had this knowledge or that he had a great career, that his audience was impressed by him, they can elicit that testimony without referencing specific instances of previous stunts that he'd made in movies.
I'll allow it. I think it does go to motive.
Yes, Your Honor.
Yes, Your Honor.
So, ma'am, like we were talking about, Mr. Jones, he'd done some pretty unbelievable stunts, right?
Yes, that's correct.
In those stunts, he didn't use CGI,
No,
didn't use stunt doubles,
no, Peter liked to do it himself.
right? It was just him.
Yes.
Then I want to talk about if Mr. Jones understood the risks of those stunts. Because in this stunt, you know that he wasn't using any stunt double.
That's correct.
There wasn't any sort of CGI to make it safer.
No, just a little bit on the ramp to cover it up.
There weren't any safety harnesses, right?
Not for the real thing, only for the practice.
You'd agree that he signed a contract agreeing to that, right?
Yes, that's correct.
Agreeing that he was going to risk his life in that stunt.
In the stunts that we did on June 20th, yes, he agreed to that contract.
In that contract, it actually mentions how he's going to hear when to pull his parachute, right?
That's correct.
An earbud, right?
Yes.
You'd agree that if that earbud failed, to the best of your knowledge, there was no backup plan laid out.
Peter could always pull his cord whenever he wanted.
Man, that's a yes. There was no backup plan if that earbud didn't work, right?
There was no backup earbud, but Peter could always pull the cord.
Wasn't a second earbud. You know that plan says Peter is supposed to rely on that earbud alone to decide when to pull it.
Yes, that's correct.
And have you ever used earbuds before?
Of course.
You ever walked a little too far away from that earbud and heard it cut out?
Sure, but I used to buy some cheap earbuds.
Man, would you stake your life on an earbud?
Objection, Your Honor, argumentative.
It's cross, I'll allow it.
Yes, Your Honor.
Man, would you stake your life on an earbud?
I'm not as daring as Peter is, but if I was told it was safe, then yes.
Then I want to talk about what Peter thought, whether or not it was safe for that stunt. Because you heard him say that this was the scariest stunt he'd ever done.
Yes, he did say it was scary.
You heard him say there were so many things that could go wrong.
That's true.
Like if he didn't pull his parachute in time.
That's true, but that's why we practiced.
But you know that Peter had a motto. Don't be cautious. Right.
That was something that he said he adopted. Don't be cautious, be competent.
Thank you very much, man. Nothing further.
Redirect?
Briefly, Your Honor. Ms. Goan, you were just asked about who made the decisions about that stuff. And was it just any old earbud that was in his ear that day?
No, it was an earbud specifically designed for him to be able to do this stunt at such a high altitude.
Were you present when opposing counsel's client actually proposed this stunt to Mr. Jones?
Yes, I was.
And what did their client say about that stunt before they did?
Stoig said that the stunt would be safe, that the stunt coordinator had given the okay.
No further questions, Your Honor. Thank you for your time.
Thank you.
Recross.
Oh, okay. Briefly.
Yes,
Yeah.
sir. Ma'am, you just told us about two things. I want to take both of those one by one. Starting with this new plan to wait longer, right? You heard that conversation between Ms. Stoig and Mr. Jones, right?
Yes, I did.
You heard Ms. Stoig lay out exactly when Mr. Jones was going to pull that parachute.
She said she wanted to wait longer. Yes, that's what she said.
Right? She said exactly 9 seconds, right?
Yes.
Said about how high Mr. Jones would be from the ground when you pulled that parachute?
To be a little bit over 1,000 feet above the ground.
After learning those details, you heard Mr. Jones say yes, he'd do it.
After Miss Doig said that the stunt coordinator said it was okay, Peter said yes.
Then let's go to that earbud, because you told us that that was some specially designed earbud. Do I have that right?
It was an earbud that had been designed, had been bought for this stunt. It was supposed to work as Peter was falling from the sky.
I just want to make it clear. Is that a specially designed earbud, or was it something they just bought for this stunt?
I don't know exactly who designed it. I just know that it worked while he was up in the air and skydiving.
Well, hold on. Let's take this. So what you're telling us is you don't know what exactly is going on with that earbud.
I don't know exactly how or who manufactured that earbud, no.
And then you told us you know that this worked when he was falling. I want to be clear, you couldn't hear that earbud when you were watching Mr. Doig fall on June 21st.
On June 21st, when Mr. Jones was falling, no, I couldn't hear inside the earbud, but Miss Doig signaled for him to pull the parachute.
So, man, that means you can't tell us if that earbud was working on June 21st.
I don't know if it was working, but she didn't say anything for Peter to pull the parachute.
Thank you very much for your time. Nothing further on.
Your permission to read an excerpt of opposing counsel's own expert's deposition onto the record. It's the oral deposition of Jess Lorenzo.
Objection?
No, Your Honor, we've waived hearsay objections
Oh,
at this point.
okay.
If anything comes up in that specific statement, we'll be happy to raise that.
Okay. Do you know what section she's going to be reading?
I'll be reading lines 62 through 68.
Why don't you tell me now if you have any objection?
If I could take a look.
Yeah.
It said 62 to, which one was it? 68. Your Honor, we have no objection to this.
Okay. You can read it.
Jones had a primary parachute and a reserve in case something went wrong. I inspected the equipment he had on June 20th and June 21st. There was no evidence of parachute failure. It was totally intact and in working order. I tested the headphone, Exhibit 4, and it worked perfectly. I even did a skydive myself with the exact same equipment, wearing Exhibit 4 while someone spoke into the walkie-talkie used by Doig. I heard them clearly while I was falling. That's all I got.
Okay. The state rest?
We are Sir Case in Chief.
Okay.
We call a witness.
Yeah. Go ahead.
At this time, we call Cole Doig to the stand.
Permission to just retrieve Exhibit 34, please.
Go ahead.
May I proceed? Good afternoon.
Hi, good afternoon.
Can you introduce yourself to the members of the jury?
Sure, hi. I'm Cole Doig.
What do you do for a living, Ms. Doig?
Sure, I work in movies. I write, direct, produce. I actually own Dragon Studios.
Can you tell us how you're involved in today's case?
Yes, sir. Actually, a year ago today, we were filming a new movie. The lead actor of that movie, Peter Jones, he died doing a stunt, and now his family is suing our company.
And I want to talk about that stunt and whether that stunt left any room for errors. Can you tell the members of the jury what exactly that stunt was?
So Peter was going to drive a motorcycle off of this ramp that we built. He was falling about 2,700 feet, but he had a parachute, of course. So he had a little headphone in his ear. I would radio when it was time for him to pull the parachute, and then he would float down to the ground.
Do you remember who exactly told you about that stunt from the first place?
Well, it was Peter's idea. He liked to bring us ideas for new stunts, and then we would try to make them safe.
And you told us he drove off a cliff and was free falling. How long was he supposed to free fall for?
So the stunt we did on June 21st, the plan was for him to free fall for 9 seconds before I gave him the signal.
Why 9 seconds?
Well, our stunt coordinator had come up with some calculations about, when it was safe for him to pull that parachute, and 9 seconds, that was still enough time for him to land safely. So we thought we could get a long enough shot, and Peter would still be okay.
Ma'am, how exactly was Mr. Jones supposed to know when 9 seconds had passed?
Right, like I said, that's why he had the headphone. I was counting in the control room on the clock, and then I would radio him at 9 seconds.
And would you recognize that earbud if I were to show it to you?
Sure, yeah, I think I would.
Approaching the witness with Exhibit 4 already in evidence.
Thanks.
Ma'am, is that the earbud you were telling us about in Mr. Jones' ear?
Sure, yeah, it looks just the same.
To the best of your knowledge, ma'am, do you know if there was any sort of backup plan if that earbud failed?
Well, he only had the one earbud in, so.
Then I want to talk about if Mr. Jones knew the risks of this stunt. Do you know if he signed any sort of contract about those risks?
Of course, yeah, there was a contract.
Would you recognize that contract if I were to show it to you?
Sure, yeah, I would.
Approaching the witness with Exhibit 33 already in evidence.
Thank you, sir.
And approaching the members of the jury. Ma'am, you're telling us about this contract. What does that contract say exactly about Mr. Jones' risk for this stunt?
Objection, Your Honor, we don't believe Exhibit 33 is in evidence. We entered 34.
Okay. Well, do you have any objections to it?
Not at this time, Your Honor, just depending on what questions they ask.
Okay, so if you move it, no objections.
Yes, Your Honor.
So we'll have it in a minute.
Yes, Your Honor, I apologize. Ma'am, you're telling us about that contract. What exactly does it say about Mr. Jones' risk when doing that stunt?
Right, it says here at the bottom, performer accepts the risks, including the risk of death, of the stunt described in the attached stunt plan document. I think it's on the back. That was the plan for that stunt he was going to do off the cliff.
And ma'am, you told us about that earbud. Was that in the contract?
It's in the stunt plan, yeah, of course. The stunt plan mentions that he'll have the earbud to get the signal.
I know you told us, ma'am, there might not have been a backup. Does that stunt plan lay out any sort of backup?
No, there's not one in here. It just mentions this earbud.
Ma'am, we spoke about how he would wait 9 seconds. Did you clear waiting 9 seconds with Mr. Jones?
Of course. I asked him the night before, and he said that was fine. He agreed.
Then I want to talk about what happened on the day of that stunt. Were you there that day?
Sure, yeah. I was there. I was in the control room.
Can you tell the members of the jury exactly what you saw for that stunt?
Sure. Yeah, he went down the ramp like he had done the day before, and he took off, and I counted to 9 seconds, just like we planned. So I radioed him, and I said, pull. But he didn't pull on the parachute. I didn't see his arm move. And so I kept yelling, pull, and he didn't. I don't know what happened.
And what happened next?
Well, eventually he pulled the cord, but I guess he was too close to the ground by then. So yeah, he didn't make it. He died.
Man, do you have any idea if something went wrong during that fall?
I don't know. I was yelling for him to pull the cord. I don't know why he didn't. I'm sorry.
Thank you very much, ma'am. Nothing further, Your Honor. Just going to retrieve those documents.
Sure.
And publish Exhibit 4 to the members of the jury.
Sure.
Cross-examination.
Yes.
Ma'am, I want to talk about what your actors were worth to you.
Objection, Your
Four.
Honor, as to argumentative.
Your Honor, it's cross-examination.
Yeah, I give you a little bit of leeway.
Yes,
so.
Your Honor.
$4 billion. That's how much your company had made off of this franchise.
That's true. It was the 7th movie in the franchise. The first 6 made $4 billion.
The franchise that Mr. Jones had starred in for 7 years.
That's right.
That $4 billion, that was 3 times more than all of your other movies combined.
That's true. It was our biggest franchise, for sure.
And the reason why, man, you thought it was so profitable was you thought because it was a crowd pleaser, right?
Of course, people love action movies.
Well, I want to talk about what you might have been willing to do to please your crowds. Because, man, you'd agree you had a record to break, right?
I don't know what you mean by that.
Well, let's talk about it. Your most recent movie had made more than $1 billion alone.
That's true. The 6th one did. That's right.
And for the 7th movie, you knew. You had to top what you'd done before.
Sure, yeah, we were always trying to make the movies better.
You wanted to make it bigger than the last one.
Sure, yes.
You wanted to make it better than the last one.
Of course we did.
You wanted to make more money than you'd ever made before off of a single movie.
Sure, I guess. Yes.
And you thought your audience would be expecting even more the 7th time around the block.
People love the movies. They really liked that franchise, so of course we wanted to make another one.
And you specifically felt a lot of pressure.
Sure, yeah. I talked with Peter about that some. We wanted to make it good.
And we'll talk about Peter in a second. I'm asking about you. You specifically felt a lot of pressure.
That's true, ma'am. I did.
Well, I want to talk about what you did under pressure. Because, ma'am, you wanted your actor to perform another stunt in this movie, right?
Well, this stunt was actually Peter's idea.
But again, in all these movies, Mr. Jones would perform a stunt.
Sure, yeah, they were action movies. So.
You knew the reason that your movies were doing so well was because your stunts were the best in Hollywood.
Objection, Your Honor. Calls for speculation.
Brief response, Your Honor.
Sure.
Your Honor, all we care about is that this witness actually believed that to be true. But we're not asserting that they really did care about the stunts.
We just ask that it be limited to that, then, Your Honor.
Sure. Overrule, don't make the argument
Yes, Your
in
Honor.
closing.
Now, ma'am, when you were gonna have your actor do this stunt, I just want to be clear what actually happened. You were gonna have your lead actor get on a motorcycle, right?
That's true, yeah. It was a motorcycle. We built a ramp to go off the cliff.
Right, they were gonna go off of that cliff 2,700 feet in the air, right?
That's correct.
And you were gonna film him free falling down the side of a mountain, right?
That's true. He was wearing a parachute, but he was going to free fall until he pulled it.
And you ran that stunt 6 times, right?
Well, we practiced it a lot more, but on the first day of shooting, we filmed it 6 times.
And those 6 times, you followed that plan you told us so much about on direct examination.
We did.
Because those 6 times, you only waited 4 seconds, right?
That's true. That was the original plan to have him pull it at 4 seconds.
But the plan you followed on the 21st, that wasn't that plan, right?
Right, everyone agreed to change the plan that night.
Right, so the actual plan we're talking about today, it wasn't the one that you all signed on.
Well, it was a little bit different. Everything else was basically the same, but we all agreed to change the timing of it. That's true.
I want to talk about what the little bit is that changed between the 6th time and the 7th time they killed him. Because, ma'am, you actually had him free falling in that little change for twice as long as the stunt coordinator had initially recommended.
Sure, we changed it from 4 to 9.
Actually, ma'am, it was your idea to change it.
It was my idea to change it. Everyone agreed.
You were watching that footage from the first day you filmed.
That's right. I went back and watched it over.
You thought that scene wasn't long enough.
That's true.
You thought the audience wouldn't be impressed enough.
Yeah, I thought that the scene was missing something.
And you're telling us that everybody agreed, right?
Right. I went to Peter. I told him I wanted to change it. He agreed with me.
You're claiming the stunt coordinator agreed to, right?
Of course. I asked her about it.
And that's what you told Mr. Jones, right? Was that the stunt coordinator agreed to?
Of course. Yes.
Gave you the green light?
She did. Yes.
Miss Audrey, could you write that down for me? Gave her the green light. We'll get to that in a second. And that wasn't the first time that she'd asked Mr. Jones to do something a little dangerous on set, was it?
Well, like I said, he always came to us with these crazy stunts. We always made sure they were safe. But sure, we've done lots of stunts before.
Man, it was your set, right?
Of course. Yes.
You got to make a lot of decisions on set.
I wasn't the only person, but I was the director, sure.
Let's talk about some of those decisions. One of the decisions was you got to pick what cliff he was gonna jump off, right?
That is true, yes.
There was one cliff that was taller and safer.
It was taller and safer, but we were told that the cliff we chose was still safe.
Right, you actually chose the shorter cliff that was less safe, right?
That's true, we knew we would
Objection,
still...
Your Honor, as to hearsay.
What was the question?
She chose the cliff that was less safe.
How's that hearsay?
Your Honor, they're referring to out-of-court statements that she's being told these cliffs are less safe. Those are out-of-court statements being offered for the truth of the matter.
So you're saying the foundation lies in hearsay?
Yes, Your Honor.
Brief response, Your
Yeah.
Honor. We're actually not referencing any out-of-court statements in this case. This is based off of the witness's rationally based perception. We're happy to lay a little bit more foundation as to how she knows that, but if I may proffer, Your Honor?
Well, let me ask you a question. Are you offering it for the truth if it was based on hearsay, or are you offering it for her knowledge?
We're really just offering it for her knowledge, Your Honor, that she believed it was less safe.
Okay. And do you intend on offering the truth in closing?
No, Your Honor.
Okay, overruled.
Just a limiting instruction, Your Honor?
Yeah, the limiting instructions issue.
And I'll re-ask my question. One cliff you thought was safe.
That's true, yeah, one was higher, which made the jump safe.
One you thought was less safe.
That's true, though I was still told it was safe.
You chose the less safe cliff because it will look better in the scene, right?
Of course, when both of them were safe options, I picked the one that would look better.
Well, you also had another choice. You could have had your actor wear an altitude watch, right?
We could have, sure.
And that altitude watch, well, that would help if, let's say, that earbud you talked about stopped working.
It would let him check what altitude he was at, sure.
Right, it would help if something went wrong.
I guess it could. It would let him know where he was in the sky.
It would let him know how many seconds had gone by.
Right, that too. It's also a watch.
Objection, Your Honor, as to improper character evidence may be heard.
Okay.
Well, we'd agree Ms. Vanderslice is talking about some of the details of this case. What they're doing is establishing character evidence, that because she was willing to take some risks in the past, that when it comes to June 21st and that actual jump, where they took longer, that she was more likely to make that decision and to wait longer.
What risks in the past are we talking about? I thought we were talking about this particular thing.
What Ms. Vanderslice is talking about, using that altimeter that tells him where he is, that she made the choice not to do that. And because she's making these choices in the past, when it comes to waiting an extra 5 seconds, she'd also make that choice.
Response on those grounds, Your Honor?
Yeah.
This is actually all part of this one instance. The instance we're talking about in the case today. And there were multiple decisions that made it such that when Mr. Jones was in the air that day, well, he didn't have any backup plan, and that was as a result of this witness's actions.
Response, Your Honor?
Yeah.
That's exactly the distinction I was getting at. Well, they're all a part of the same case. What Ms. Vanderslice is arguing today is that that negligence comes from waiting that extra 5 seconds. 5 seconds for the cost of a life. And that's a separate decision from what we're talking about in these cases. They're using that prior evidence to show action in conformity therewith.
You have the last word. Is that really your theory? Are you limiting it to just the 5 seconds?
No, Your Honor. We're contending that there were multiple decisions that made this incredibly unsafe, one of which was to ensure that there would be no backup plan, so that when Mr. Jones was in the air, and perhaps maybe there wasn't a signal, that there was no backup plan, and that's why he died.
Yeah, overruled.
Yes, Your Honor.
Go ahead.
And I'll re-ask my question. When he was up in the air, he didn't have an altitude watch.
No, that's what we had agreed on with Peter.
That's because you chose to not have him wear one.
That's true. He agreed to it.
And when you ran that stunt for the 7th time, half the crew was missing, right?
That's right. Some people weren't there.
The stunt coordinator wasn't there.
That's true.
You didn't wait for them to come back to the set, did you?
No, I didn't. I was actually the one giving the call, not the stunt coordinator.
You didn't pay them to come back to the set to make sure everything was okay?
No, we just run it the day before, so.
That's a no on my question.
No, she didn't come back. That's true.
And you're telling us that you did everything you could to make sure this was safe, right?
Of course, yeah. Peter was the lead in the movie. We wanted the stunt to look good, but we also wanted it to be safe.
And you were in trial when the agent came to the stand.
Yes, ma'am, I was.
You heard her say that she was in the control room that day too, right?
She was. That's true.
You heard her say you never made that signal for Mr. Jones to open his parachute.
I had to say that, but that is not true.
You're telling us she's wrong, right?
I don't know what I'm telling you. I'm just telling you that's not what happened.
And you also told us a moment ago that that stunt coordinator gave you the green light.
She did, yes.
Now, at this time, we'd like to read a line from from the stunt coordinator's affidavit.
Have all hearsay objections been waived to this too?
Yes, Your Honor.
Okay. So, and there are no other objections to the reading of the transcript?
If we could get the line.
Yeah.
170 to 171.
Thank you. No objections.
Okay. See.
Question. How did you respond? Answer. I said, no way, that's cutting it too close, especially when I'm not there. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Before we do that, if we could read out a portion of that same witness's deposition.
Okay. I take it there's no objections?
Opposing counsel just let us know
Of course.
these lines.
203 to 208.
Your Honor, we actually have an objection to a part of those lines on 207. It references a settlement agreement and actually testifies to the contents of what was actually in that settlement agreement. We have an objection to hearsay within the hearsay to the content of that settlement.
Okay.
Yes, Your Honor. We don't need any of those statements for the truth of the matter. This goes to the witness's bias. If I may explain a little bit about what we're getting at here.
Sure.
Yes, so effectively, this witness settles with the Jones family after an initial lawsuit was filed against her. As part of that settlement, she agrees to write this deposition and to, if called to testify on behalf of the Jones family. So that just goes to her bias, what she thinks at the time.
Okay.
Your Honor, we're fine with them reading lines 204 to 205, referencing that they were originally sued and they settled with the family. To actually go into the contents of what that settlement agreement was, what those discussions were, we believe they are using that for the truth to prove that there even was bias.
So what you're saying is that they can't elicit the fact that she agreed to testify on behalf of the
Yes,
state?
Your Honor, the actual content of the settlement itself is hearsay within hearsay.
Okay. I don't think it goes to the truth. I think it goes to bias. So you can read it.
Yes, Your Honor. Were you originally party to this lawsuit? Answer. Yes. At first, the Jones family sued my company and Dragon Studios. But then I settled with the Jones family. What were the terms of the settlement? The settlement agreement releases me and my company from any liability for Peter's death and says that I agree to testify for the plaintiff in this trial. And no redirect examination, or the witness take her seat at counsel.
Yes.
And with that, we rest. We're ready to go to closing arguments.
All right. Does anybody need a break before we go to closings? Yeah. Yeah. How about we do 5 minutes? Yeah.
Great.
And while we're taking a break, what trial is this?
This is Vanderslice versus
Walker.
Kunde.
The K.
Walker's a nice guy. Though.
Yeah. Okay.
So, yeah.
That's right. All right, I think we have everyone here. Both parties present, ready to proceed with closings.
Yes, Your Honor.
Yes, Your Honor.
State.
May it please the court,
Yes.
Mr. Kunde, members of the jury. That was 5 seconds. That was 5 seconds. And it might not feel like that long sitting here in court today, members of the jury. But for Mr. Jones, he wasn't just sitting in a courtroom watching me snap my fingers. He was falling down the side of a mountain waiting for the people he trusted with his life. Waiting for a signal that never came. Why? Why did that signal never come? Well, today you learned it's because this defendant company cared more about those 5 seconds than they did about his life. And you know what they say, members of the jury, a picture is worth 1,000 words. But in this case, members of the jury, to this defendant company, those 5 seconds of a clip, well, that was worth more than $1 billion. So it didn't matter. It didn't matter if they wanted to dangle their lead actor in the air for another 5 seconds. It didn't matter if that went against safety protocols and the stunt coordinator was out of the country. It didn't matter. If it might end in Mr. Jones dead and disfigured at the bottom of a mountain. Because to them, those 5 seconds were worth more. And that's why. That's why we're here representing Mr. Jones's family, suing the defendant company for negligence. Now, it's like I told you at the start of today's trial. The judge is going to explain to you what that means. It means we have to prove that 3 things were true. 3 things were more likely than not. That the company didn't exercise ordinary care, that a company should. That Mr. Jones suffered harm and that their lack of care actually caused that harm. And I want to walk through how we met that burden today. Because we showed you first that it was their plan. Now, they spent day in and day out trying to convince you today that this was all Mr. Jones's plan. This was all his idea. And sure, members of the jury, maybe he decided that he wanted to take the motorcycle off the mountain in the first place. But he didn't just agree to jump off a cliff, no questions asked. No, he agreed to do it if the defendant company kept him safe, if the defendant company followed that plan that they all signed on. But their witness took the stand today. The producer had to admit that they were done filming. That crew, the crew that was supposed to keep safe, had gone home. Including, hello, the stunt director. And so it was actually the producer. The producer, she was the one who asked Mr. Jones to hang on 5 seconds more. She was the one who pulled them aside to try to change their mind. She was the one who decided that those 4 seconds just weren't enough. And those 5 more seconds were worth more. And when she made that decision, well, you heard that she couldn't even bother to tell Mr. Jones the truth. And you see, that's important in today's case because opposing counsel, they brought a burden of her. And a part of that burden is to prove to you not just that Mr. Jones said yes, but that he said yes with all of the appropriate and accurate information. That he understood the magnitude of the risks. And that's just not what you heard today. Because you were told when she was talking to Mr. Jones that she told him the stunt coordinator said this was safe. But members of the jury, that's not actually true. We read that deposition to you today, and that stunt coordinator said nothing of the sort. And that brings us to our second point today. Before she changed the plan, she was told not to. You see, it was from the beginning, members of the jury. She had no intention of listening to that stunt director. It was in one ear and out the other. She said, no way, it is cutting it too close. They hear, hey, let's do it. She says, oh, 4 seconds isn't enough. They hear 9 seconds. seconds is probably fine starts on day one, when the producer thinks that one clip is safer and one clip is less safe but looks better on screen. Which one does she pick? She picks the one that she thinks looks better on screen. Day two, she has a choice to give her actor a watch that would really keep him safe if something were to go wrong, if the earbud were to, say, malfunction. But the thing is, she chooses not to. Because, of course, members of the jury, what's more important than safety? Accessories. She says, no, save the watch, you don't need it, because God forbid something were to ruin the scene by, I don't know, the actor staying alive or something. Because time and time and time again, she sacrificed his safety for the scene. The problem, members of the jury, is she came to court today and you heard her excuses. She told you, you know what, that stunt coordinator was saying she didn't approve it. That's not true. And you know what, that agent who's saying I didn't call the signal, I waited too long, no, that's wrong too. Members of the jury, think about what she's asking you to believe. She's asking you to believe that it is more likely than not that she is the only witness out of all those deposed who's telling the truth. That she is the only one who's telling the truth, even though she's the only one whose company is on trial, and she is the only one with a motive not to. So when you go back in that deliberation room, you have to find this company liable. Because they decided that those 5 seconds were worth more than Mr. Jones's life. Find them liable. Thank you.
Your Honor, before we proceed, if we could retrieve a few exhibits from the members.
Yeah, go ahead.
Thank you very much. May I proceed?
Yes.
All day, Miss Vanderslice and I, we've been in this courtroom, we've been saying the same things. This plan wasn't safe. I mean, we both brought a witness on this stand here, and we asked, Miss Vanderslice asked, you chose to go to the less safe cliff. We agreed. You chose not to have him wear an altimeter. We agreed. This plan wasn't safe. But he still said yes. Members of the jury, if this plan, if it sounds crazy to you, that's because it is. And if you're frustrated by that, it's frustrating. It is so hard to believe that the reason Mr. Jones isn't going to his kids and his wife tonight is because of his own choices. It's frustrating to think of all these people in this room who had a hand in that plan. They chose to rely on an earbud? I mean, a piece of plastic? That if it cut out for even 1 second, then he wasn't safe anymore. So members of the jury, today the plaintiff has charged Dragon Studios with negligence, and they have a burden today. They have to prove their case is more likely than not that they were negligent. They weren't able to do that today. But even if you agree that they were, well, then you have to assess our burden. Whether or not Mr. Jones, when he did this stunt here, assumed the risk. We told you we were going to prove that today by showing you 3 things. That this plan had no room for error, that he agreed to it, and that's why he died. So let's start with that first piece. That this plan had no room for error, because you heard today how Miss Doig and Mr. Jones came up with the new plan. That they wait until the very last second before pulling that parachute, and that they would rely on that earbud. And now the plaintiff tried to tell you that that was some sort of specialized earbud. But on cross-examination, you heard that's not the case. That sure, maybe someone else skydove with it. But they brought this case. They have to prove to you that the reason they waited those 5 extra seconds wasn't because of that earbud. It was because of a piece of plastic. So that brings us to that second piece. And Mr. Jones agreed to it. Because you heard today and you saw this contract that he signed. That he agreed, that he knew when he did that stunt, his life was on the line. You heard his own words, how this was the scariest stunt he'd ever done. That he knew so many things could go wrong, that he could pull his parachute too late. What's so frustrating about that is that it's his choice. That whether or not it's negligence or whatever, it's irresponsibility. Because that man should be back with his family right now. He should never be in a part of this case. This plan wasn't safe. But it was his choice. And in a few moments, Ms. Vanderslice might come up here and say, well, in this contract, it doesn't say 4 seconds, but what you heard today is that Ms. Doig went to Mr. Jones, said, are you okay with this? He said, yes. She might stand up in a few moments and tell you, well, maybe she lied about whether or not someone had proved it. She told you a few moments ago that she's the only one with a motive to lie about that. But that's not what you heard today. You heard that that witness who denies what Ms. Doig said about that plan being safe, well, she already settled with the plaintiff. She's got just as much, if not more, reason to lie than Ms. Doig. So that brings us to our last one. That it was that risk he agreed to that caused his death. Members of the jury, today you heard what happened on July 21st. You heard how he drove his motorcycle, just like those photos, off a cliff. And how just like he feared, his parachute didn't open in time. Jury, Ms. Vanderslice is trying to tell you that this studio, they valued that scene at billions of dollars. They were willing to push all their chips in on that one scene. And members of the jury, it just doesn't make sense. Because whether or not they would get $1 billion for this 9-second, 15-second scene, would you throw all that away for the next $1 billion on movie 8 and the next $1 billion on movie 9? Doesn't make sense, members of the jury. And today it's your job to weigh these facts we've presented before you and to make sense of it. It's not an easy job. It's not easy to pick who to blame. It's not easy to say that a man who died did so on his own choice, his own volition. It's hard. But that plan wasn't safe. And he still said yes. Thank you very much for your time.
May I ask how much time I remaining for everyone?
36 seconds.
Members of the jury, it seems that a lot of this case hangs on this earbud, at least opposing counsel. But the thing is, members of the jury, we read defense counsel's own expert who tested that earbud and said it was working just fine. But even if it wasn't, members of the jury, it was their client's job to make sure it was working fine. And there's another problem. Their case hinges on this idea that that Mr. Jones said yes, but Mr. Jones said yes under false pretenses. Because he didn't know that they thought those 5 seconds were worth more than his life. Find the line.